Good afternoon, everybody. Thank you for joining us for another webinar event in Conn Carey's annual OSHA webinar series. I am absolutely thrilled today to be talking to you about something other than COVID-19, although I feel like I'm somehow betraying the pandemic by talking about something other than that. But it has been such a focus, I'm sure, for all of you, as it has been for us over the course of 2020. But a relief today to be able to talk about something that is sort of classic OSHA. And that is process safety management. And we're giving our annual late fall process safety management update, talking a little bit about the state of affairs for OSHA's PSM standard and EPA's RMP rule and other process safety related issues like the CSB accidental release reporting rule. I'm Eric Conn. I'm one of the founding partners at Conn Carey and chair of the firm's National OSHA Practice Group. I've been practicing in this field for 20 years. I recognize most of the names on the call today, so I think most of you know me and I know you, but for any newcomers, I started my practice 20 years ago practicing alongside the former first general counsel of the OSHA Review Commission and practiced with him for over 10 years before starting my own practice at a smaller national employment law firm, and then 6 years ago helping to launch Conn Carey, the boutique firm focused on OSHA and employment issues. And I work with my clients across the full range of workplace safety and health law issues, principally dealing with federal OSHA and the state OSHA plans on compliance assistance to enforcement matters, including significant enforcement matters and criminal investigations and prosecutions. I'm pleased to be joined today by two of the experts at our firm in our OSHA practice on process safety issues, and I'll let them introduce themselves here.
Hi there, this is Micah Smith. I'm also a partner in Conn Carey's OSHA Workplace Safety Practice Group. I'm also very happy to be participating in this webinar. I was fortunate that on my first day in private practice, my first project was a PSM matter, some citations that we defended the client for. And so since day one, I've been doing process safety. Like Eric, cover a full range of OSHA topics for our clients, whether they're process safety or not. And we do everything from counseling to litigation at the trial level and even the appellate level these days. So I'm glad to be here.
Hi, my name is Beeta Lashkari, and I am an associate at Conn Carey and also a former attorney investigator of the U.S. Chemical Safety Board. I represent employers in the full range of matters regarding the OSHA Act and handle the full range of litigation related to contesting OSHA citations. I also manage inspections and investigations by OSHA, the CSB, EPA, and other federal, state, and local government agencies. It's a pleasure to be here with you all. I will turn it back over to Eric to go through our agenda for today's webinar.
Thanks. Yeah, and today is, it's a non-COVID day, which is nice, and the heavy focus on PSM. The interesting thing is there hasn't been an extraordinary amount of activity in this area, not surprisingly because of COVID, right? OSHA has been otherwise occupied, and so have most of the employers around the country. So we're gonna, get through today's subject on things that are new and a little bit of forward-looking issues, what we expect perhaps in a Biden administration as it relates to process safety management. In particular, what might they be doing with the RMP rule? What might OSHA under a Biden administration look like in terms of PSM enforcement? What's going to happen with the National Emphasis Program, the PSM National Emphasis Program, and we are just a couple of short months away from the true effective date, the effective date minus the grace period year for the CSB's accidental release reporting rule. So we will talk a little bit more about that, what to expect over the next year. And then finally, probably the biggest PSM update, at least in my life, as it relates to my life, is we got a 10th Circuit decision in the Wynnewood appeal that Micah and I and Beeta briefed, and Micah and I argued before the 10th Circuit. So we'll give you a little bit of background on what happened in that case and what that means for the industry. And I think Micah is going to lead us off today talking a little bit about PSM enforcement, in particular the NEP developments over the course of the last year or so.
All right, so as Eric said, one of the major developments or non-developments this year is just the continuing ChemRef PSM NEP, and so we wanted to give you an update on this. November, we love doing our November update. One challenge that we have with it is it's at kind of an awkward time for OSHA data. As many of you know, OSHA runs their, and the rest of the federal government runs their fiscal year beginning on October the 1st and ending on September the 30th. As that relates to an NEP and as it relates to their collection of data, they consider inspections to be included in a fiscal year when the inspection opens inside that fiscal year. So you'll see the column here with FY18. That's going to include all of the inspections that began between, I've got to check myself, make sure I get the dates right. I believe it is between October the 1st, 2017, all the way through September the 30th, 2018. And so FY19 is going to go from October 1, 2018, all the way through the end of September 2019. So unfortunately, the way they run that, if these inspections, many of them take 6 months, the ones that just began, let's say at the end of, the reason we don't have FY20 data yet is those that began on September the 30th won't conclude or don't have to conclude until the end of March in 2021. So OSHA will not get around to having a full set of data from FY20 until probably March or April. So that's why you're seeing what looks like slightly older data here. It is the most updated information that the agency has, and so we wanted to make sure we showed that to you. FY18 was the first full year of the ChemRef, the new ChemRef PSM NEP, and you can see some of the statistics here. Of course, we've got this special line for petroleum refineries, but this includes a wide range of things. And you can see the breakdown. What we wanted to highlight here is just what feels like the steady nature of this NEP. 223 inspections in FY18, 169 under FY19. That is a fairly low number when you consider the full range of companies that are potentially subject to this NEP. So what we're seeing here is a slow and steady progression, just in terms of the number there. Interestingly, you know, we're seeing something close to a 50-50 split between programmed and unprogrammed inspections. That reflects OSHA spending a significant amount of time planning ahead, choosing targets, and going in to inspect them. And on the other hand, still catching some other folks when they happen to be out there, whether it's on an employee complaint, an incident, or some other thing. The in-compliance rate there is your chances of ending a PSM NEP inspection without any citations. And so that seems to be about a 34-33% chance that's holding steady. Between 18 and 19, of course, the number of citations per inspection ticked up, and also the total penalties went up a fair amount. We haven't got a good read from OSHA on why that is, if there was a considered or effort to raise those, but you know, that's what we can see out there. So that's the numbers. We will be looking to update those again in March or April with some updated information. That will be a very fascinating set of data because, of course, it will include essentially the entire pandemic. FY20 will run from October 1, 2019 all the way through September 30th, 2020. So that'll be a curious set of data when we get it. So moving on to the next slide, we wanted to show one subset of inspections under the ChemRef NEP that's easy to track because it's a smaller number is the refinery inspections. With having less than 200 refineries in the country, it's easier to chart OSHA's progress through them than it is through other entities, whether they're facilities that have ammonia refrigeration or chemical manufacturers, anything like that. So what you can see here is as I said earlier, a kind of a slow but steady progression in the year 2018. You see we've got 4 inspections listed there, a larger number in 2019, spread out all across the country, though with a fair emphasis there in Region 6. Of course, they have more refineries than I think any other region. Moving on to the next slide, you can see what's happened more recently. Still a few more kicking off in 2019. And then you can see a gap. We had the Calcasieu inspections start in January, Ergon started an inspection in January as well, and then a giant gap. Of course, that's when the pandemic hit. And we had been projecting throughout this year that we were thinking OSHA was going to take a pause from doing very many of these programmed inspections, especially just because they were overtasked with COVID enforcement actions, particularly related to healthcare facilities. And that held true through most of the year. But interestingly, right here in October, just last month, in Region 6, we see OSHA kicking off 2 programmed inspections of refining facilities. So, you know, it may be that they were reading the situation as there was a lull in COVID cases or COVID enforcement down there on the Gulf Coast. Numbers were at a lower level as compared to earlier in the year. So we see them kicking off these 2 inspections. Those are the only 2 that we have seen OSHA open up. So we don't know if other regions are going to do the same thing. We don't know if Region 6 will continue given the current COVID numbers. And as that situation is developing, we'll keep an eye on it. But just be aware that OSHA is, seems like they've not totally neglected this. There's still a chance of getting an NEP inspection even during this pandemic. Moving on. Here's the official word on the NEP during the pandemic. There's not been an official pause, but as I said, they have some significant practical limitations to deal with. Their inspection numbers have been drastically down. This is not, that 25 per week is not NEP focused. That is programmed inspections anywhere of any type, anywhere in the country. That average is about 1 per state that is in federal OSHA. So you can see they're very much falling off of that. All right, so they're focusing very much on COVID-19 things. We were expecting, as I said, pause in programmed NEP inspections, though that seems to be changing, or it changed at least last month. And as always, if you do have a PSM incident, there OSHA is likely to inspect, probably about as likely as always to inspect. And there is some risk that they will turn that into an NEP. There's a decent chance that they could do a modified NEP. They might claim credit for it and still spend less time on site because of COVID restrictions and their policies for conducting in-person inspections during the pandemic. But you could still get an NEP during the pandemic. So moving on. You know, here's our tagline for the future of the NEP. OSHA likes it. It gets them into these facilities that they otherwise rarely have a reason to go and inspect, absent a catastrophe or the occasional employee complaint. This NEP has no expiration, so the pandemic is not affecting grand plans for completing this. They have had internal targets for how many facilities they want to make it through. We think it's obvious that they've either lifted those goals or entirely, or just modified them to be much more conservative. But this process isn't going away. Whether the pandemic goes away in another few weeks or another year or two, this initiative is here, and we think it's here to stay. There's no signs that it could go away. So keep it in mind, even as you're focusing on your compliance during the pandemic. Just know that this will still be out there, and will come back around when all of that is over. So moving on to the next slide, I think this is where we kick it back to Eric, and much to his chagrin, he gets to talk more about COVID and PSM.
Yes, now I'm back in my comfort zone. Thanks. We talk a little bit here about OSHA's COVID-19 enforcement discretion policy, because it does have PSM implications. And the idea here was that a little bit into the pandemic, back in the middle of April, OSHA issued an enforcement memo that was intended to provide relief to employers across all industries who are having difficulty coming into compliance with certain regulatory requirements because of the pandemic. And the idea was there was a recognition by the agency that the pandemic has created unprecedented issues, right? Because of travel bans, because of supply chain issues, because of just general infection control strategies like social distancing and things like that, that there were certain regulatory requirements that it was, if not impossible, very difficult to maintain compliance or come into compliance. And it typically involved those things that have annual or recurring type of deadlines to them: annual training, medical surveillance programs, audiometric testing, things like that, where it could be a greater risk to come into compliance, or because of travel bans or the like, it's impossible to come into compliance. And so this was intended as a temporary enforcement policy where the agency would relax enforcement as to those types of obligations if you meet certain criteria. On the next slide, we'll get into what OSHA expects to see from employers before they get the benefit of this enforcement discretion. First, the employer has to be unable to comply, and to be able to demonstrate why they are unable to comply with a standard that requires some sort of recurring duty: audits, reviews, training events, in certain kinds of inspections or testing, things like that. And the reason why they're unable to come into compliance is because of COVID-19, and the employer has made and can demonstrate that it has made good faith attempts to comply. In those circumstances, OSHA shall take efforts into strong consideration in determining whether to cite a violation in those circumstances. But if the employer does not or is not able to demonstrate any effort to comply, or why compliance would be more hazardous, citations will issue. And the idea here, just to give you some idea of how we've been counseling some of our clients who have encountered this, the demonstrating your good faith attempts to comply might be efforts to source certain equipment. It might be efforts to schedule certain activities like audiometric testing, where the supplier or vendor or the party that provides that service for you says, hey, we're banning all travel, we're not allowed to make that trip, or as a professional industrial hygienist, we advise you that this is a dangerous practice to march a bunch of people through a trailer to do audiometric testing on the same equipment. So we're just going to defer that for the year. But you've shown some effort to try to come into compliance and can demonstrate why you're not able to because of COVID-19. And even when you do that, there's an expectation that you will make some effort to address the hazard otherwise. So if it is, we're not able to do audiometric testing, we'll be able to demonstrate, or should be able to demonstrate, that we've done nothing that would increase noise volumes at our workplace, or maybe even took some steps to reduce production to lower the noise volumes in the workplace, or did a refresher training on the importance and proper use of hearing protection, until we're able to come back into compliance with that recurring requirement that we weren't able to meet because of COVID-19. And then finally, OSHA expects you to make good faith attempts to return to compliance as soon as normal operations resume, as soon as it becomes possible to come into compliance. So again, we talk about this enforcement discretion because it has PSM implications. In the memo itself, OSHA included an Annex A, which was a non-exhaustive list of examples of situations where OSHA could foresee that employers would have some difficulty maintaining compliance because of COVID-19, and they had an entire section of that annex about PSM requirements. And they identified a few specific elements of your PSM program that they could understand that you might have difficulty satisfying during the year of COVID. That included conducting, proper PHAs or PHA revalidations, at least completing them. Maybe you could undertake parts of it, but not certain parts. And they would expect to see what efforts you have taken, but they would understand if you missed a PHA revalidation deadline because of COVID, right? Maybe you use a third-party administrator for your PHAs and the third party wasn't able to travel. Maybe you're not able to, convene a group of experts in the process as the standard requires, people knowledgeable about the process from among your operations and maintenance and management teams because of social distancing issues or whatnot. I do know a lot of consultants out there and a lot of companies out there did press ahead with their PHAs using virtual platforms with a reasonable amount of success in achieving an effective PHA doing that. And so that may ultimately push OSHA to say, you know what, we don't think it's so reasonable to defer some of these actions. But right now it's on their radar that these would be challenging compliance obligations to meet during a pandemic. Other examples they gave were the annual review and certification of operating procedures, which often require walkdowns of the facility, and careful reviews with operators about those procedures. And so to the extent that that's not feasible during a pandemic, OSHA seems to understand that may be the case. And then training. And training is another example where again, if you are able to do this, if you're able to do, computer-based training, online training, or training in, meeting social distancing requirements, they're going to expect you to do it. But if you're not able to do it, if it really does require in-person training, maybe even training using a third party or hands-on training and demonstration events, and you've determined that can't be done or can't be done safely, OSHA appears to be ready to understand and accept that if you've made good faith efforts. This is what was in Annex A. On the next slide, we get into some additional information we collected from discussions with OSHA over the course of the year, shortly after this memo issued, and then periodically after that in discussions with the agency with questions raised by some of our clients. They made clear, the OSHA leadership, the PSM leadership team at OSHA made clear that that's not an exhaustive list. Those three things under the PSM standard that they recognized are likely covered by the enforcement discretion memo, and said, look, it's really about a principle. Go all the way down to the bottom of this slide here. It's about the principle of the memo can apply to just about anything, but the burden to show good faith is higher for certain requirements than others. But the idea is that the principle, if you are unable to comply because of COVID, you've made good faith efforts to try to comply and can't do it, you've made good faith efforts to otherwise address the hazard, and you make good faith efforts to come back into compliance as soon as possible, that can apply to essentially any element of PSM. But there's a few things that they said, it's going to take an awful lot to demonstrate to us that you can't do it, or that you've effectively managed the hazard in the interim. And if you can't effectively manage the hazard in the interim, then you need to shut down the operation or you need to come into compliance. And those examples, again, the bottom half of the slide, management of change, it's going to take an awful lot to demonstrate to OSHA that you could not come into compliance and that you were effectively able to manage the safety concerns of a potential process change or a change covered by the MOC requirements without actually conducting an MOC. The one that I know that they emphasized the most to me is that mechanical integrity, the inspections and tests themselves, their expectation is that if you can't meet those requirements, you should not be operating that equipment. If it's outside of compliance with your mechanical integrity schedule or the Reg A gap that sets whatever frequencies should be conducted, if that cannot be achieved, they expect you to shut down that operation or to come into compliance. And that's one that, we could see the challenge. If you depend on a third-party expert to do certain types of mechanical integrity inspections or tests, and they're unable or unwilling to travel, that's going to put you in a tough situation. But OSHA has signaled that they view that with a whole lot more scrutiny under the principle of this enforcement discretion. But otherwise, they say, look, we talked about PHAs, but certainly that same analysis would apply to compliance audits. We talked about annual, certifications, review and certification of operating procedures. That would apply here, we think, pretty effectively under this memo. Mechanical integrity. I emphasize that the thing that OSHA is most concerned about there is conducting the inspections and tests. They're less concerned about the annual requirement to conduct training on your mechanical integrity program or periodic requirement to do training on that program. If you can't achieve the training, they may understand that more and exercise that discretion to not cite than they are about not conducting inspections and tests. And similarly, certain actions that may be required to close PHA or compliance audit recommendations, there's not a hard and fast rule about how quickly that needs to get done. As a general rule of thumb, it's a year or 2 years, depending on the complexity of the requirement. I think if you can demonstrate that, sourcing parts were unavailable, having contractors come in to conduct some sort of construction or renovation or, capital project because of the pandemic, and so it's taken us extra time to close a PHA recommendation, I think they should be more understanding under this enforcement discretion memo. So that's what's going on with the impacts of COVID-19 on PSM and how OSHA is viewing that through the framework of their enforcement model. A couple other things that I wanted to share as sort of a forward-looking approach here, right? I know that there's still a lot of folks who don't think the presidential election has been determined yet. And wherever you fit on that spectrum, I'm going to go ahead and forecast a little bit about what you might expect from PSM under a Biden administration, because it seems a reasonable likelihood that that's where we're headed to early next year. So let's talk about some things that might affect OSHA generally and PSM specifically. I think one thing that, the first time in my 20 years practicing in the field of OSHA, we have now gone an entire 4-year presidential term without a head of OSHA. I think relatively early on, President Trump installed a deputy assistant secretary at OSHA. That's a role that does not require Senate approval. He nominated somebody for the head of the OSHA for the assistant secretary job. But Mr. Mugno was that nominee, never got confirmed, never got a vote from the full Senate floor for a confirmation. It never seemed to really be a priority for the administration, much heavier focus on judicial nominations and confirmations. I think we'll see a different approach from a Biden administration. I think very early on, in the very, very first days of the administration, they will install a deputy assistant secretary at OSHA, again, because it doesn't require Senate approval. And perhaps that same individual installed as a deputy assistant would be nominated for the assistant secretary job and just wait for that confirmation while already in the building implementing the Biden administration's agenda at OSHA. Or, a separate individual may be nominated, but I think that nomination will take a little bit higher priority from the administration. And the reason is, a big part of Biden's campaign message has been about what he would do at OSHA. And that's not typical. As somebody who lives in a OSHA bubble, it was pretty remarkable to see the focus in his campaign about OSHA, and in particular around COVID-19. But the idea being, within his first 100 days, he expects to have a COVID-19 emergency rule, a federal emergency rule put into place, which I think would really require moving quickly on leadership at OSHA being put in place to drive that process. So I think we can expect to see both those things. Trying to crystal ball a little bit who we might see in some of those really important roles like Secretary of Labor or Assistant Secretary or Deputy Assistant Secretary for OSHA. We've seen that Senator Bernie Sanders has expressed a lot of interest in the Secretary of Labor job. And I think we can, imagine the kind of approach that a Secretary Sanders would take at DOL, very aggressive. Talk about, relaunching rulemaking across all of the divisions of labor, heavy focus on enforcement. I think the message would and the agenda would come pretty strong under a Secretary Sanders. Other names that we've heard being entertained for senior leadership positions, either at the Department of Labor or at OSHA specifically, Jordan Barab and Debbie Berkowitz, two very senior OSHA officials during the Obama administration, are surely being considered for either the top job at OSHA or a undersecretary position in the Secretary of Labor's office. Doug Parker, an interesting name here, who we know has been named to and is operating right now as part of Biden's labor landing team, his transition team for labor. Doug is right now the division chief, the head of Cal OSHA. He was formerly in the Department of Labor during the Obama administration. Between that time and becoming the head of Cal OSHA, was the head of WorkSafe, a worker safety advocacy group based out in California, and has been over at Cal OSHA for over a year now. And one thing that we know that Cal OSHA is doing right now, I'm going back and forth between this webinar and working on comments to Cal OSHA's emergency temporary COVID-19 standard that they are promulgating with 5 days notice. Draft rule published on last Thursday night and to be voted on by the Standards Board this Thursday. So at some point this Thursday. Doug Parker, obviously, as the head of the agency, is a big part of that effort. I think we could see, something very similar happening at the federal level when he is installed, if he is one of the contenders for a senior job at Labor or at OSHA. And in terms of PSM, we also know that Cal OSHA has been extremely aggressive on the PSM front. In rulemaking, in their own version of an NEP out in California, very aggressive enforcement. So I think we have a sense of what a Parker-led Fed OSHA would undertake as in terms of PSM. So what does all that mean with this new leadership and a potential or likely new administration coming in on the PSM front? Well, just remember that Vice President Biden, as part of the Obama administration, that prior administration worked sort of as fast as they possibly could on major process safety and risk management reform throughout the second term of the Obama-Biden administration. As a result of that West Fertilizer incident, there was the executive order from President Obama that drove the RMP amendments and drove a very active PSM reform rulemaking process that got all the way through the SBREFA process before the term ended and President Trump took over. That very active, very fast-moving PSM reform rulemaking was moved to the back burner, moved to the long-term agenda in the regulatory agenda during the Trump administration, and essentially no activity was taken during the last 4 years. I mean, I think there was some effort to digest comments and feedback that was gathered during the SBREFA process, certainly analysis and tracking of what EPA is doing at RMP. But I expect, the very first regulatory agenda under a Biden administration would be to move that PSM rulemaking from the long-term agenda back to the active rulemaking agenda and resume that process. And I think we can expect a serious effort to try and complete that PSM reform rulemaking during a 4-year term upcoming during a Biden administration. I think we can also expect to see OSHA under a Biden administration resume focus on more complex inspections like PSM inspections. Remember, it was during the Obama-Biden administration that OSHA adopted for the first time the enforcement weighting system. And the idea of that program was to sort of break the old habit at OSHA to, I don't want to say that there was a quota, but there was, an effort to evaluate and maintain a certain level of enforcement that was evaluated pretty strictly based on the number of inspections that were conducted. And as a result of that, you would see, often late in the fiscal year, a real heavy focus on very, very simple surface kind of inspections. You would see inspections at construction sites where the agency could come in, a compliance officer could come in, and in basically a drive-by inspection, maybe a half a day, they could inspect 4 or 5 general contractor and subcontractors and say, look, I conducted 10 inspections today, and get their inspection numbers up. Well, OSHA implemented the enforcement weighting system during the Obama-Biden administration to recalibrate how OSHA evaluated their enforcement activity to try to discourage drive-by inspections and instead encourage more complex inspections. So you would get more inspection units, enforcement units for more complex inspections like PSM inspections, which often require multiple compliance officers and several months and hundreds of man hours of time. A lot of area offices would reject those, would do the bare minimum of those, would do everything they can to avoid those in favor of other kinds of inspections. That's why we saw a shift towards the tail end of the Obama-Biden administration to focus more on PSM enforcement, launching the new emphasis program and getting into refineries and chemical plants more often. We've seen a shift back. They're still technically implementing the enforcement weighting system during the Trump administration, but they rejiggered the enforcement unit calculation that essentially went right back to the old way of calculating things that took away a lot of the incentive for doing more complex inspections. I expect that to be revisited, enforcement units to be rejiggered again, and again to have a heavier focus on more complex inspections. So expect more activity from OSHA in our process industries during a Biden administration. I think one of the things that we've experienced in the first few years of the chemical facilities and refining, petroleum refining joint PSM national emphasis program is that often those inspections have been pretty surface level. Typically the inspections that are triggered by an incident or an employee complaint and they morph into an NEP inspection have not felt at all like the old NEP inspections. They've been, single inspector, pretty surface level, not very intensive. My expectation is that under a Biden administration, that the NEP inspections, I think the NEP will continue. I don't, maybe it won't even change at all in terms of the words and the directive, but I think the way that these inspections are conducted and how it feels to be the subject of one of those inspections is going to start to feel a lot more like the old NEP inspections, maybe not the refinery, original refinery NEP, but the chemical facilities NEP, which was a lighter version, but not quite as superficial as I think many that we've seen during the last 4 years. So that's a bigger deal coming, I think, in that regard. The other thing I think we'll see that also is often related to PSM is under a Biden administration. I think we'll see more focus on worker safety criminal investigations and prosecutions. And the most common area, I think, it's hard for me to even remember a worker safety related prosecution that was not process safety related. So I think this, knowing that we're going to see heavier focus on worker safety criminal, expecting that we're going to see that, would also mean, expect to see that in the process safety space in particular. And then other areas that will affect all employers and all issues, but where we see a heavy dose in the process safety industries is OSHA's regulation by shaming program, enforcement press releases. Those very often accompany enforcement in the process safety space, as well as the National Office of OSHA interjecting themselves into the enforcement process more often. I think we can expect to see that. And because process safety enforcement tends to be on the higher profile side, I think we can expect to see a heavier focus or more intervention by the national office in that process safety enforcement. So that's my crystal ball based on what we can expect to see during the Biden administration. I think we'll turn it over now to Beeta to talk about the CSB accidental release reporting rule.
Great, thanks so much, Eric. So now I'm going to talk a little bit about the CSB reporting rule. All right, so just first, just to give a quick history of the reporting rule. As you might know, the CSB is a relatively newer agency compared to OSHA and EPA. The CSB was created out of the Clean Air Act amendments of 1990 and was required within those amendments to establish reporting regulations. Those amendments specifically state that the board shall establish by regulation requirements binding on persons for reporting accidental releases. So fast forward 8 years later, the CSB finally actually becomes operational, it becomes funded. And that's why, we tend to think of the agency as around, 20 years old or so. And then fast forward, another 10 years or so. And in 2009, the CSB takes its first steps really towards creation of a reporting rule. And it does that by publishing an advance notice of proposed rulemaking. And in that 2009 advance notice, the agency fields a lot of questions that, quite frankly, it did during this current rulemaking. Like how long should it take to make a report? What should the definition of substantial property damage be? And so on. So, but really, the first rulemaking effort, it started there and ended there in 2009. The CSB received comments to their questions, but that was sort of the end of that. It just stagnated. Then fast forwarding about another 8 years later, and a group of worker safety activists filed a complaint against the CSB in federal court, basically seeking to compel the agency to finally promulgate its statutory mandated reporting regulation. And that case, in case you're interested, it's Air Alliance Houston versus CSB. And after a couple years of litigation, a DC district court judge, ordered the CSB to promulgate its reporting regulation. And, importantly, it set the judge set a time frame to that CSB would have to promulgate the rule within 12 months of his ruling. So now to anyone who's been involved in rulemaking before, you're probably thinking 12 months is lightning fast, and it was. There were major concerns about whether the CSB or any agency really would be able to get it done in that short time frame. But the CSB did issue its notice of proposed rulemaking on December 12th, 2019, giving the public about 30 days to comment, with the deadline of January 13th, 2020, to submit them. And you should know our firm did submit comments on behalf of a coalition of employers and trade associations. And, we certainly spent a lot of time over the holidays, but we were able to get a robust set of comments in there, even in that short time frame. So come February 6th, 2020 of the new year, the CSB did complete its reporting rule before the court-ordered 12-month deadline, and the rule was published in the FR on February 21st, with the date of effect being 30 days afterwards. So the rule technically became effective March 22nd or 23rd. So that's sort of the long and short, the history of where we are and how we got here. One important thing to note, and that Eric mentioned earlier, is that in the preambles to the final rule, the CSB did note that it would observe this grace period of 1 year. Really to give the regulated community a chance to, get used to the rule, to get, to come into compliance. So CSB said it would not refer violations of the rule to the EPA for enforcement unless there was, a knowing failure to report. Okay, so what does the reporting rule say? On its face, it's pretty simple. but there are some major nuances that will very likely, or hopefully at least with time, get worked out. So the rule requires owners and operators of a stationary source to report to CSB within 8 hours any accidental release that results in a fatality, serious injury, or substantial property damage. And you'll see all these phrases have regulatory definitions, which were, of course, major sticking points during the rulemaking. Fatality is pretty straightforward, but serious injury, that did undergo quite a bit of change from proposed rule to final rule. At first, the definition was extremely broad, capturing injuries and illnesses that OSHA wouldn't even require to be recorded on their 300 logs. So, but CSB did recognize, that slip, and that it didn't mean to capture, all those types of injuries and illnesses. As you know, the CSB tends to focus more on those, very catastrophic releases. So it rolled back its definition to essentially track now OSHA's reporting regulation, not recording, reporting. And another point of contention, of course, was this definition of substantial property damage. So the CSB has created a bright line rule where if the property damage, and what's really important about this is property damage does, then that's a separate, there's a definition for substantial property damage and then a definition for property damage. The definition of property damage does include outside property damage and loss of use of equipment. And in the preambles, CSB did indicate it should also take into account business interruption costs. So if all that damage amounts to $1 million or more, that could trigger reporting obligations. So a lot of comments submitted about that, but it seemed like CSB sort of held firm in creating this $1 million threshold. And if you're wondering about, what types of chemicals should trigger a report, you'll see that it's not really apparent in the text of the rule itself, but it's actually embedded in the definition of accidental release. So accidental release is defined as an unanticipated emission of a regulated substance or other extremely hazardous substance into the ambient air from a stationary source. So there are sort of two categories of substances that you're looking at, right? There are those that are already regulated, and then there's this other group that, CSB describes as other extremely hazardous substances. And the CSB defines that latter category, of other extremely hazardous substances by looking at the consequence of what the substance did. I think somewhere in the preamble, actually, the CSB said something like, when there's an accidental release that results in a death or serious injury, there shouldn't be any question about, whether the substance is hazardous. So, where we stand right now, without any further guidance from the agency, at least not yet, is that the scope of substances that could trigger reporting obligations is very broad. Okay, and just one other element about the reporting rule is that the CSB does recognize that there is a lot of duplication in these various reporting, regulations that industry must follow. So it said, to the extent you've already made a report to the National Response Center, if that's something you had to do for that specific incident, then there's no need to complete a full CSB reporting form. You can just report the NRC ID number to the CSB. But if you do that, if you choose to use that method, then you'll have to make sure you report the NRC ID number within 30 minutes of making the report to NRC. So that's really just the framework of the rule. That's the gist of it. Okay, so moving on to the contents of the report. I won't go through these one by one, but it generally asks for, some basic information about the facility, who's making the report, some basics about the incident, whether there, what happened, whether there was a fire or explosion. It also asks, what kind of material was involved, seeking a chemical abstract number or other identifier. And then it gets into a little bit more specifics, and the CSB did take, into account that, the fact that you're reporting within 8 hours, you're not going to know everything. So it added this quantifier, if known. So if known, the amount of the release, number of injuries and fatalities, number of people evacuated if there was an evacuation, and so on. It also seeks your estimated property damage. So for this, the CSB has developed a fillable form, and that's available on their website, csb.gov. If you don't see it right away, you just go to the investigations tab at the very top of the page and click on that, and you'll see it drop down, and that says incident report rule. And that'll direct you to this form and instructions on how to fill it out. Okay, so before I hand it back off, I just want to speak a little bit about the future of the rule. As I mentioned before, and as Eric mentioned, we are still now in this 1-year grace period that CSB gave the regulated community, time to get used to the rule. But that grace period ends in only 4 more months. So it's, it's gone by pretty quickly, especially given, how, basically right after the rule was published, more or less, the pandemic hit. And, I think it's fair to say employers, you've been dealing with COVID-19 related issues as your primary concern. But we have not heard any word from the agency about extending their grace period. So we do want to put this on your radar as something that you should be gearing up towards, because, come March 22nd, 23rd, the grace period will end and CSB will start referring suspected reporting violations to the EPA administrator for enforcement. And enforcement, as you can see, can include administrative penalties and civil or criminal actions. Another element of the rule that we wanted to put you all on notice of is that the CSB did acknowledge that, this is a reporting rule, not a disclosure rule, but accidental release records may be obtained through the Freedom of Information Act or FOIA process. So that is something that is potentially very concerning, and even more perhaps, in the preambles, CSB stated that it would proactively disclose, subject to federal statutory prohibitions, initial incident information once per year. So there, I think there was an acknowledgement in the preambles that this is a reporting rule, not a disclosure rule, but, the information is still out there to be obtained through the FOIA request process, but also CSB said it would, proactively disclose this information once per year. We have not seen any data thus far, but if the CSB is true to its word, that data could be published, disclosed publicly on or before late March, when we are hitting that 1 year mark of the rule being in effect. And just the last point we wanted to make about the future of the rule is that the CSB indicated that it would release guidance on the rule. Throughout the preamble, really, the CSB noted, various areas where it would be amenable to issuing guidance, like, for example, about whether an explosion is a per se accidental release, whether injuries or damage from an intentional release is reportable, and clarification, of course, on this broad definition of extremely hazardous substance. So to date, we have not seen any guidance. That could be because the CSB too is dealing with the pandemic and everything that comes along with it. There have also been some major changes at the board level. The board is now operating with only one board member, Chair Lemos. But, you know, we wanted to put this on your radar as well, that, you know, that is something that CSB said it would be issuing. That guidance was promised, and hopefully we do see that sooner rather than later as this grace period ends. Okay, with that, I will turn it back over to discuss RMP.
Thanks, Beeta. So EPA is the last of the three process safety related agencies we want to talk about, and we wanted to cover this, not spend a terrific amount of time on it, because I know we've talked about it probably on our last 3 or 4 PSM updates, but wanted to make sure we gave everybody a status update on where things stand with EPA's RMP rule. So let's talk about the history of changes. As everyone knows, the RMP rule has been around for 20 some odd years. But after the West explosion in 2013, I think, it became a priority of the Obama administration to increase some focus on significant accidents, things like that. And there was a push to have EPA update the RMP rule. So at the very tail end of the Obama administration, there was a push, and I think we've characterized this as a rushed rulemaking to get that through, get it finished before the end of Obama's term in office. So in January 2017, the RMP amendments became a final rule as part of the Trump administration's deregulatory push. Almost immediately, the EPA started trying to roll back the RMP amendments. So they published a delay rule in June 2017. That delay rule that effectively just delayed the implementation of the RMP amendments. The delay rule was challenged by environmental groups. That litigation progressed through the courts. By May of 2018, EPA proposed the substantive revision of the RMP amendments in what they termed the reconsideration rule, sometimes called the rollback rule. So we've got a two-track process here where we've got EPA working on the permanent rollback of the rule, and you have litigation challenges to their delayed implementation. So shortly after EPA proposes their substantive reconsideration rule, the DC Circuit vacated their delay rule in September 2018, effectively, or making the RMP amendments effective essentially immediately, at least the parts of the rule that had a timeline to already be in effect. So you had this strange situation by fall of 2018 where the EPA is trying to roll back this rule, but the delay has been kicked out, so the RMP amendments are the law of the land. Moving on, that was the status quo for about a year while EPA worked on the reconsideration rule. We were expecting it to go a little faster, but finally by November, December 2019, that reconsideration rule was finalized, and that rolled back most of the RMP amendments. So not all of them, there were some small parts of it that stayed in effect. But for the most part, for the largest pieces of the RMP amendments, we just rolled back to the original RMP rule. As you might have expected, immediately after the reconsideration rule was signed, it was challenged in the courts by activist groups. And so that litigation started in December of 2019. And so we were wondering, what'll happen in the last year of Trump's first term? Will we see the courts strike this down like they did the delay rule? Interestingly, there is, in addition to challenging the rule in the courts, there is also a mechanism by which groups can petition EPA to reconsider the reconsideration rule. I think we should have probably planned ahead the naming of the rule with knowing some of the terms that we're going to get overlapped here. But in February 2020, there were 3 different groups that petitioned EPA to reconsider the reconsideration rule. And as a result of that, the litigation was paused in the DC Circuit. So from March of 2020 all the way through the present, that litigation has been paused. The petitions to reconsider the rule, it took 6 months for EPA to act on them, but in August, of this year, EPA formally denied those petitions, saying essentially the concerns with the reconsideration rule were not valid and that they intended to continue with the reconsideration rule as originally promulgated. With that part of the saga closed, that means that the litigation in the DC Circuit can pick back up, and the next filings due to the court, I believe, are in December of this year. So to just recap, we start with RMP amendments promulgated by the Obama rule. The Trump administration tries to delay the implementation somewhat unsuccessfully. They successfully finalized a reconsideration rule that rolled back most of the amendments. Now we have challenges to the rollback, essentially asking the RMP amendments to be put back into effect for alleged failures in the rulemaking. So there's a lot going back and forth here, and on top of that, we have an upcoming change in administration. So the question is, what happens next? The most immediate thing that is occurring that we'll see some developments in will be this litigation. We can expect to see some filings in December to kind of chart a path for where this is going to go. As we look at the litigation, we're considering is the DC Circuit's decision in the Air Alliance case, that's the case where the DC Circuit struck down the delay rule, does that foretell what's going to happen in this litigation? In that decision, the DC Circuit was highly critical of the EPA, saying that the delay rule had no relation to EPA's purposes. They said it did nothing to protect the environment, and that it was just wholly incompatible with EPA's mission. So would the DC Circuit take on the same approach and say, rolling back the RMP amendments, is that so far outside EPA's purpose that it's an impermissible rulemaking? That's certainly a possibility. Complicating this, of course, is with the new administration, the attorneys who will be defending EPA in the litigation will no longer be appointed by the Trump administration, they'll be appointed by the Biden administration. Will they take a different approach? Will they defend it less zealously? Some of the key trade associations in this space have set themselves up to be interveners in this case. So even if the Biden administration really backed off the defense of the rule, it's possible that the interveners would, try to carry the water forward and keep things moving forward. But it's really a complicated picture here. And so in addition to litigation, what will we see from a Biden administration in rulemaking? And what about enforcement? What do we see there? So here's where we talk about our kind of prognostications. What are the options for things moving forward? The way we see it, there are probably 5 different things that could happen, and there are, of course, blends between these 5. But on the next slide, you can see, number one option is the Biden administration could defend the reconsideration rule in court zealously. Rather than looking at this from a policy standpoint and what they want to see happen in the process safety space, they might say, look, we need to defend our ability to make rules, and this is a kind of an institutional thing that we need to defend. That's one option. They could defend it zealously. Another option is rather than continue the litigation, they could try to reach a settlement agreement with the plaintiffs there in that litigation, right? So we have some states, we have a union, we have some of these interest groups that are advocating for more aggressive environmental regulation. It's possible that a Biden administration could negotiate an end to that litigation by way of a settlement agreement, and through that process could commit to changing things in the rule. That's kind of a creative option there. Another option could be if we wanted to continue the absolutely confusing nature of things here, you could see the Biden administration try to roll back the reconsideration rule such that we could go back to the original 2017 RMP amendments. That's a possibility. Another approach, in one that I'm kind of hopeful for, just so we can stop talking about reconsidering the reconsideration rule or rolling back a reconsideration rule, a Biden administration could pursue a new or a different RMP rulemaking process, ideally in conjunction with OSHA. Eric talked earlier about how we think that OSHA is very likely to move the PSM rulemaking back onto its front burner. If we saw that happen, it would make a lot of sense to see EPA doing similar work and trying to coordinate. That's I think that would be a very good way of moving forward, to the extent that we're trying to make changes to the rules. And of course, the last option is, you know, we could see the RMP rule just sit exactly where it currently stands. It could be that this is not a high enough priority for a Biden administration. They may want to focus on other air or water issues or climate change issues with their time in the EPA. So it's very difficult to project what could happen here. I think we're all sitting here, and in January I'll be making my popcorn ready to watch and kind of take in the scene, see where this goes. But we will definitely keep you all updated as things develop. Leaving that in the rearview mirror, we wanted to cover one more thing, and that is the most significant case development in with regard to OSHA's PSM standard, and that's the Wynnewood case. So, real quick review of what's going on here. There was an OSHRC decision from early 2019, a case that goes back into the early part of the 2010s. Basically, the case involves a boiler that features some amount of connection to an operating refinery by way of steam and fuel gas headers. And through the litigation in the decision, OSHRC ruled that the boiler in that case was covered by the PSM standard by virtue of its interconnection with the headers and the pipe racks to the covered process. The processes talked about there were an FCC and an ALKY unit. The OSHRC ruled that it didn't matter that there was no HHCs contained within the boiler, that interconnection itself was enough. And as an alternative reasoning, OSHRC also ruled that the co-location, that the boiler was co-located with these covered processes sufficiently that it could be covered, and that OSHA needed to only prove that there was a possibility of involvement between the two in a potential release. There was some speculative testimony from OSHA's expert that the accident could have been much worse, and even though the boiler explosion did not cause a release from one of the covered processes, it could have, and that was enough for OSHRC to say that this was that the equipment was sufficiently co-loaded to be covered by the PSM standard. All right, so this went up to the 10th Circuit, and after being briefed and argued over the last year, the 10th Circuit released an opinion about 2 or 3 weeks ago, and essentially just affirmed OSHRC's decision. Did not affirm every avenue, every theory that OSHRC proceeded on. The 10th Circuit basically ignored the co-location argument and instead focused on the things that we have highlighted here. Number one, there was a strong focus on what the majority claimed was the plain language of the definition of process, leading to the conclusion that there's no need for a vessel to contain highly hazardous chemicals in order to be PSM covered. So that was one. The majority also relied on the language in the first sentence of the definition of process, where it says any activity involving highly hazardous chemicals, saying that was broad enough that you could have PSM coverage of the boiler. We have a little quote here that from the decision, the majority said a vessel need only be part of any activity that involves a highly hazardous chemical, a very tangential relationship to a covered process there.
Right, and really, I think they almost confuse themselves. Trying to find a way to support the government's argument. The government didn't even argue that. I mean, the idea here is that's the definition of process, not covered process. And nobody really disputes that a boiler is a process, but that's where the 10th Circuit kind of ended their analysis. But I'll leave my sour grapes for another day.
No, I think that's exactly right. What's interesting in this statement here, the statement is on its face true, that you only have to have these. That's how broad that first sentence is. But if you leave behind the threshold quantity, you've essentially eviscerated the rule, and that's what happened in the opinion here. I have a gas grill that has some propane in it. It is an activity that involves a highly hazardous chemical, but there's simply no argument that it's ought to be PSM covered because there's no threshold quantity, and that's something that got left behind. Another finding here was that interconnection alone is enough to establish coverage. The majority in the 10th Circuit ruled that the language essentially establishing a causal relationship between interconnected vessels, that it didn't apply to interconnection, it only applied to co-location. That supported OSHR's decision. And so that was another ruling there from the majority. Interestingly, there was a strong dissent in the case. Judge Bachrach wrote a pretty vigorous dissent and outlined the reasons that he would have reached the opposite conclusion. He was very supportive of Wynnewood's arguments that you cannot have PSM coverage of a vessel that doesn't contain highly hazardous chemicals. That was really the focus of his dissent. So there's some significant disagreement there. So with that, quick summary of the opinion, the real question then is, what happens next, right? There was, I didn't cover it here, but there was, while OSHA won on the PSM coverage question, Wynnewood, I'm confusing myself. OSHA won on the PSM coverage question, but Wynnewood won on the successorship repeat characterization issue. So given that it was each side won one piece, either side does have the ability to seek additional review either from the 10th Circuit or the Supreme Court. This review is discretionary. We're now at the phase where there's no right to any further review. If the 10th Circuit would like to rehear it, either the panel or an en banc setting, they can if either side petitions, or the Supreme Court could grant a petition for cert. Neither of those things is guaranteed, but we could see some developments there. In either case, we can expect to see decisions made on whether either side will ask for review, probably before the end of 2020. So this could be the end of the road for the Wynnewood case, or we could see some future developments. We'll have to wait to see what 2021 brings on that one. Eric, did you want to add anything here?
No, I think that's a good review.
All right, well then we've reached the end. I'll let you close us out.
All right, well the big last thing I do want to share with everybody, if you haven't seen news of this, we do have our third annual Process Safety Summit coming up this year. As many things in our lives are different because of COVID-19, this year our gathering in Washington, D.C. with senior leadership at all of the process safety agencies will be done virtually this year, but it will carry on, and we're going on December 8th and the morning of December 9th. It'll be shorter sessions, less of your day to account for Zoom fatigue, but we are carrying on, and I hope you all can join us for that. Contact us if you need more information about that. I also encourage you to check out our blog and our webinar series. Today is the penultimate program in the series. One more coming up in December, but we'll also be making announcements sometime next month about the program for next year. So please join us for that. And I think that's our program for the day. I think we've kept you all for about as long as I reasonably think is reasonable. So we've got some questions that have come in the chat session. I think what we'll do is we'll follow up with those of you that asked those questions and get back to you in writing after today's program. So thank you everybody for joining us. Thank you for joining us throughout the year and for being, supporters of our practice and our webinar series. And we'll look forward to talking with you again soon. Stay safe and have good holidays.